Mr. Talbert. Ready?
Good morning, and may it please the court. Tyler Talbert on behalf of the plaintiff, appellant Miss Karen Ledford. We've reserved 5 minutes for rebuttal. This case is about abuse of the corporate form. The Kasi Roping Club's directors admitted that they ran a dangerous event. They shifted that risk to the public by maintaining a corporation that was consistently and intentionally undercapitalized. On that factual backdrop, we make 3 submissions to the court here today. First is that there's a fact issue on veil piercing. Second is that equitable tolling is proper in this case. And third and finally is if doubts remain on these legal issues, certification to the Supreme Court of Texas is the appropriate result. So let's turn now to the first of these, that there's a fact issue that the organization was a sham to perpetrate a fraud. And I want to take this up in kind of 2 big chunks. First, legally and factually, the evidence does create a fact issue on that point. And then second, let's tackle this notion that somehow nonprofits are categorically immune from veil piercing. As to the first of these, the Supreme Court of Texas has told us very clearly that veil piercing is appropriate whenever the organization is used to achieve an inequitable or an unjust result. That's the standard. They told us in Castleberry in 1986 it doesn't require actual fraud. I think an absolute roadmap to this guidance is the PJC, Texas Pattern Jury Charge, Chapter 108. And 108.4 presents this simple question to a jury. Does use of the organization result in injustice? And so that's the question. Is
a little more complicated than that. Because here, the basis that you're arguing that fraud exists is centered around undercapitalization. Is that correct?
That's absolutely true, Your Honor.
And generally, the law is that undercapitalization in and of itself is not a basis to set aside the corporate structure that appears to veil. Now, what is the evidence in addition to undercapitalization that you are asking us to consider that will support your claim of fraud?
Sure, and I agree absolutely that undercapitalization standing alone isn't a basis to pierce the veil. Because, look, organizations may run their bank account a little thin, they just may have had a hard couple of years, and that's perfectly fine. What the standard is consistent, gross, intentional capitalization. And let's talk about why that makes sense and then what evidence there is.
And that's still undercapitalization.
Well, and to the extent we say categorically undercapitalization, even if it's intentional, consistent, and calculated, that standing alone cannot be a basis to pierce the veil, I would push back on that. The court in Castleberry told us that it's a viable veil piercing. And the court didn't just create that. If we remember 2 years earlier, the Supreme Court of Texas in Lucas v. Texas Industries explained to us why undercapitalization is a good theory. It said when you run a risky business, but you are undercapitalized, you are shifting that risk to innocent members of the public. And so...
Why wouldn't that apply in all undercapitalization situations?
Well, and what, admittedly, the authority on this is a little scant, and what we see the secondary sources saying is that it's an inadequate level of assets considering the activity that you've run. And so, look, if you're...
Still undercapitalization.
Sure.
You've got what is the additional evidence of fraud that you have other than undercapitalization or its consequences?
And so the burden for the plaintiff in a tort claim is to put forward evidence of constructive fraud. And let's talk about what the Supreme Court of Texas told us that is. It isn't actual fraud. It is not intent to defraud. It is that it has a tendency to violate a person's confidence.
That's not what I asked you. Okay. I asked you what is the evidence, not the theory, but what is the evidence that you have beyond undercapitalization?
So the evidence here is that Joe Suttle, the president of the Kasi Roping Club, he testifies, look, we brought in probably gross $10,000 to $20,000 a year. At the end of each year, we netted about $8,000. At the end of every single year, we swept the account. We spent it on one thing or another, or we gave it away. And so on that basis...
That's undercapitalization.
It is, and I guess what I would suggest is undercapitalization is a viable basis to pierce the theory.
Well, but I thought you told Judge Jolly that you agreed that undercapitalization in and of itself is not enough to pierce
Correct. Intentional, gross, consistent undercapitalization is a viable theory to pierce the veil. It does not require any additional showing. It does not require actual fraud.
Your best Texas Supreme Court decision for that proposition is what?
That's Castleberry v. Branscombe.
And in Castleberry, was the corporation giving the money to charity?
No, it was a contract case.
Yeah, so that's the thing that seems difficult is that it's a town of 500 people. The reason they're sweeping the accounts at the end of the year is to give the money away to support the community. And I'm having a hard time connecting the dots between that and an intentional, what is the standard? An intentional effort to empty bank accounts to prevent recovery for potential tort claimants?
Let me take that up in a couple pieces here. First is, it does not have to be intentional to prevent recovery. Remember, if we fell under the T-Box statute 21.223, we would have to show actual fraud. We just have to show constructive fraud, that they swept the accounts and the net result was something that violated public interest. And so that's the standard. But then let's address your concern, how we're not seeing how we get there. I think there are two elements that assuage that concern. The first is that the Texas legislature has noted that nonprofits are specially situated. They provided them a specific immunity in Chapter 84. If you're a nonprofit, if you're a Cossie Roping Club, get insurance. Your volunteers will have complete immunity. They didn't do that. They didn't keep insurance, and they didn't keep their bank accounts. And the second thing I would note that's kind of assuaging that concern, well, aren't nonprofits somehow different, is that remember the question that's going to go to a jury. Would it be inequitable for this result to stand? And so what you're voicing is exactly the arguments that I suspect we will hear if we were to get to a trial. That, look, we gave it away to charity, although there's no evidence corroborating that other than the deposition testimony.
Is there evidence to suggest that's not true?
Well, we asked Mr. Settle what happened to the money. He says, well, we spent it or we gave it away. And we said, do you have evidence of that? And he said, well, no, I don't know, nothing else that's in the bank records. And so it's a little thin on that point. But to address your concern that, well, look, is this really going to get us there? What I would submit is on this record where you're operating an admittedly dangerous event and you're sweeping the accounts at the end of the year, that is injurious to public interest, and that does, at the very least, we're arguing, Your Honors, create a fact issue as to injustice and inequity. And I want to note this just really quickly is the Supreme Court of Texas told us that in all but the most exceptional of cases, this is a fact question for a jury. Again, they told us that in Castleberry. They reiterated that in Phillips in 2015. And so that's the appropriate result here. I will take up very briefly this notion that somehow nonprofits are categorically...
I was going to ask you about something different, actually, because, I mean, certainly in my view, if we have to get into the issue you want to talk about, we should certify to the Texas Supreme Court, but that's just my view. What about the limitations?
Sure. So,
to the roping club within the statute of limitations, and you amended to add the individuals. Tell me why, then, the claims against the individuals are not subject to the statute of limitations.
Absolutely. And so what the Supreme Court have told in Gentry in 1975 and in Matthews is that an action to pierce the veil is a viable remedy even after limitations have run on the underlying tort. And let's look at the language of Gentry. Remember what Gentry told us? It said it stops the running of limitations.
Are those both alter ego cases?
Those are both alter ego cases.
Gentry is you sue an organization, and in fact, it is the alter ego of another organization. Matthews was...
It too was an alter ego case.
It was an alter ego case. Is there a distinction then with this case? Not an alter ego case, is it?
And let me take that... I'm going to have three parts to that answer. This is a sham to perpetrate a fraud case. It is not an alter ego case. But they are the same for two reasons. First is, here's what Gentry told us. It said, we're not going to thwart these equitable considerations by adherence to any particular theory of liability. That's what we'd be doing. We'd be saying, well, alter ego claimants get the benefit of tolling, but sham to perpetrate a fraud claimants do not. It kind of flips that concern on its head. Second, what the Matthews court tells us is the exact same concerns that compel us to apply equitable tolling are the exact same concerns that apply to veil piercing generally. It didn't say just to alter ego cases, it said to veil piercing generally.
Well, how so?
Well, because it's all aimed at achieving an equitable result and preventing the entity from being used as a cloak for fraud.
Isn't it true, or you tell me if it's true or not, that to the plaintiffs was available information with respect to undercapitalization well before the statute of limitations would have run. Why shouldn't that weigh against applying equitable tolling to allow them to be sued outside the statute of limitations?
Sure, and let me take that up in two parts, legally and factually. Legally is what the Supreme Court have told us is kind of a mechanical rule. It stops the running. When you name the entity, we've stopped running. But factually, I would push back that we had information well within limitations. Remember, the event occurs in June of 2017. It's not until August of 19, August 27th of 19, that we learned for the very first time there's been consistent undercapitalization.
I understand that's your theory about undercapitalization, but didn't you have information about the capitalization of the company long before that?
What we had was in December, we had information suggesting that they were that they did not have insurance. It was also rife with errors. It said they were an unincorporated association. It said people were involved. We then, in April of 19, got an affidavit that said we only have $8,000 in our bank account. Mind you, that was not produced in discovery. They voluntarily handed that over. I'd submit to the court if they thought, well, this is going to put us on the hook, this is good enough to trigger a claim, they wouldn't just have handed it over. That not until August 27th of 19 did we actually have that consistent undercapitalization.
All right, so that's your factual point. Your legal point is you're saying that there is a bright line rule under Texas law that says if you have a veil piercing claim under whatever theory, you sue the corporation, that stops the clock.
That's precisely what Gentry says.
You're saying Gentry says that.
I would hesitate to call it a bright line rule, and I know this is...
You called it a bright line.
Well, I apologize. I retract those words. That's not correct. The problem here is we're dealing with equities. We're dealing with a lot of things that require equitable considerations. Remember the jury charge? Would it result in an equitable question? And I get, look, we like bright line rules. We don't like this kind of more factored test.
In a diversity case, I like to know what Texas law is.
Well, and I do, I'm happy to address the certification issue on that point. But as to equitable tolling, yes, Gentry and Matthews both address this. And here's what goes awry in the lower court's order. Don't even mention those cases. If you're going to take up equitable tolling, you've got to address those two cases that kind of stand for this proposition. Didn't even mention those. And so...
You could contend we should certify not only on the veil piercing as to nonprofits, but also as to the to the statute of limitations?
That's correct. And I think the concern, and let me address that equitable tolling question. I think the concern you raised is kind of the looming question. Gentry and Matthews were both alter ego cases, but they applied a broad equitable tolling question. But to your point, is it still a good theory and a sham to perpetrate a fraud in an undercapitalization case? We submit that the case law out there says absolutely yes.
We would typically look to intermediate courts at that point. Do we get help there?
I apologize.
Do we get help from intermediate Texas courts?
As to the
equitable tolling issue.
The only thing that we saw the district court rely on was this weird opinion from San Antonio that purports to not apply equitable tolling, but again, doesn't even touch Gentry or Matthews. And so what you've got are two Supreme Court of Texas opinions and nothing, neither case addressing those. But
Are you talking about Matlock?
What's that?
Is the case you describe as weird, is that Matlock?
It was Matlock v. McCormick. That's
right, but all the facts are pretty similar.
Well, what I think occurs there, and if you read the case, is she's trying to figure out who the right entity is, and she pleads discovery rule and fraudulent concealment. I don't think she ever tees up the correct equitable tolling theory, and as support for that, look at the case. It doesn't mention Gentry or Matthews once. I'd submit if it was taking up the issue, it would have noted those cases. But, to the bigger point is that, look, these are big questions as to whether or not undercapitalization is sufficient with consistency, degree, and intent. And Judge Jolly said, look, I push back on that notion. We believe that under Lucas and Castleberry it is. But look, the actual application there is scant. The nonprofit issue. We're going to hear from appellees, we heard from the trial court, categorically, nonprofits cannot be liable. Well, we've got a robust authority, both statutory, case law, and secondary sources saying, well, that's not correct. And the third issue is this, the interplay of kind of Castleberry and 21.223. Remember, Castleberry was 86, the T-Box statute was 89. There are these looming questions in tort cases, which secondary authorities have said, this is an elusive case, that ordinarily you get contractual or quasi-contractual claimants that absolutely fall within 21.223. We're not that case. The questions for a jury are equity, injustice, and constructive fraud.
Now, whoa. I mean, what is the issue? What is the disputed issue of fact that a jury would decide in this case?
They would decide whether the sweeping of funds, for whatever reason the defendants claim, whether the sweeping of funds was constructively fraudulent and resulted in an
A
unjust.
legal question, is it not?
What's that?
Legal question, is it not?
The factual question, as it would be submitted, would be 108.4b of the Texas Pattern Jury Charge. Does the use of the corporate form result in injustice in this case? That would be the question for the jury.
Well, okay.
Anything else? Thank you, counsel. You'll have
Thank you.
time for rebuttal. Ms. Altman, you have 12 minutes.
May it please the court. My name is Jacqueline Altman, and along with Mr. Greg Ave, we represent the appellees who are members of the board of directors of the nonprofit corporation, the Kasi Roping Club. And in this case, the district court granted summary judgment on 3 separate and independent bases. I will discuss the first 2 bases, which involve why Ms. Ledford's claims are all barred by the applicable statute of limitations, as well as the lack of authority under Texas law to pierce the corporate veil of a nonprofit. And Mr. Ave will discuss the legal insufficiency of the veil-piercing claims. In order to prevail—
We're told on the statute of limitations quite vigorously by counsel opposite that there is maybe a bright line rule, but a rule that says if I sue the corporation and I have a veil-piercing theory, that stops the clock.
So what the cases—
We heard Gentry and Matthews.
Correct. So
Correct.
Gentry—
Is that right or not?
No, Your Honor. First, Gentry was pre-Castleberry, pre-Texas Business and Organizations Code, pre-this entire modern construct of veil piercing. Second, as Your Honor's pointed out, it's an alter ego case. As the court noted, in the finding of an alter ego, we treat these 2 entities as identical. They are interchangeable. Because of that, by suing the initial entity timely, you are essentially, for all intents and purposes, suing the alter ego as well, because there's no difference. And what Gentry actually stated was that in those circumstances, when we look at the facts, a plaintiff may be entitled to equitable tolling. We agree. A plaintiff may be entitled to equitable tolling after limitations has passed. Ms. Ledford has not demonstrated her entitlement to equitable tolling at all. And equitable tolling is the only method of tolling that she has pled or argued before this court. If we look at how the actual timeline occurred in this case, it is undisputed that all of Ms. Ledford's claims stem from an accident in June of 2017. She knew of her injuries on that date in June 2017. Texas has a 2-year statute of limitations for personal injuries. So the statute of limitations ran on all claims based on that incident in June of 2019. She did not sue the directors until October of 2019, 4 months after the statute of limitations. Ledford now bears the burden to demonstrate why she was not able to do that and show her entitlement to equitable tolling, and she hasn't done that. She completely ignores the fact that she essentially sat on this information, decided not to investigate, not to prosecute her case as is required, and then months later decides to add the defendants with absolutely no reason for the delay. And so Mr. Talbert said that in August of 2019 was the first time that they learned that the corporation was consistently undercapitalized. And first, although Mr. Ave will discuss the legal insufficiency issue, there is no case that draws a distinction between just undercapitalization, as Your Honor said, which is insufficient, and consistent undercapitalization. I have not seen a case cite for that in their brief, nor did I hear Mr. Talbert say that today. And so I don't actually understand what that distinction is.
So is that not a reason to certify?
No, Your Honor, because undercapitalization in general is not sufficient. Undercapitalization plus a lack of insurance is not sufficient. Because we know that, undercapitalization alone cannot be enough.
Well, I'm sorry, remind me the best case for undercapitalization plus lack of insurance.
Yes, Your Honor, I believe it is Ramirez. And I can get you another one as well that's in our briefing. And so, even if we consider the fact that they are claiming August 2019 is the first time that they learned of this consistent undercapitalization, if that is a distinction, what they're omitting is that they never asked until July 2019. They didn't serve discovery requests on the nonprofit organization until after limitations.
I'm sorry to keep moving you between the two issues, but I'm still fascinated by the legal question on the veil piercing theory. What do you make of your friend's argument that the nonprofit should have gotten insurance and failed to?
I think there's a distinction between what somebody should do, what best practices are, and what the law allows you to pierce the corporate veil for failing to do. And the law does not allow you to pierce the corporate veil of a nonprofit just because they didn't have insurance and were undercapitalized. And I also want to point out that originally the appellant had argued with regards to the lack of insurance and has dropped that on appeal and is solely arguing undercapitalization. However, regardless, the cases show that lack of insurance plus undercapitalization is still legally insufficient to maintain a veil-piercing claim.
What was the reason that they gave for the failure to acquire insurance?
Honestly, just an oversight and the fact that
I thought they said they thought someone else had insurance or something of that nature.
I believe that they believed that Johnny Hoyle, who was the producer of the rodeo, who was also sued in this case, they thought that it was his job to have insurance. I think he thought it may have been someone else's job. I don't think he's been deposed yet. And so I think it was a misunderstanding.
Well, then do you concede that if they had intentionally foregone insurance, that would be the additional evidence that you would need to establish, to pierce the corporate veil in addition to undercapitalization?
No, Your Honor, because there are still cases that state undercapitalization and a lack of insurance. Those two alone are still legally insufficient to pierce the corporate veil. And I think if we look, Mr. Talbert's characterized the actions of the directors as this intentional, malicious, bleeding the corporation, swiping funds. What happened was in his deposition, this is on the record at page 533, counsel asked, he said, question, some of the money goes back into hosting the next rodeo. Answer, yes, sir. Have you ever encountered a situation where you have extra? Answer, yes, sir. What happens to the extra funds if you have extra surplus? And this is what Mr. Talbert claims is the intentional bleeding of the funds every year. Answer, it goes to improvements, upgrades. We donate to local charities, the Volunteer Fire Department, CASI 4-H, and the Limestone County Youth Fair. This is supposedly this nefarious bleeding the corporation for the purpose of not being able to compensate a plaintiff, which also, Mr. Settle actually said in his deposition, he never imagined that this situation would occur. You cannot have an intentional avoidance of a situation that you didn't even imagine was possible. He said, upon further reflection, does he understand maybe someone could get injured? Yes, but he said, honestly, we never thought of that possibility before. So in this case,
How did this injury occur?
So this was the result of barrel racing, and there is an alleyway where the barrel racers exit on the horse. And Miss Ledford was crossing the alleyway, the very end of the alleyway where the barrel racer came out. And in the trial court record, I believe there are videos, people yelling, telling her, get out of the way, move, and then she got hit by the horse.
I mean, so with respect to the events that are going on inside the ring, whatever it's called, I assume there's a great possibility of injury there. Who has insurance to cover that?
Your Honor, I don't know the answer to that in this case. I believe the directors of the Cossey Roping Club thought that Johnny Hoyle, the producer of the rodeo, was the one.
I was gonna say, evidently it must be someone else.
Yes.
We're talking about insurance with respect to something different than the events going on. I take it.
Yes.
Maybe that doesn't make sense.
Yeah, and so I think that's some of the question is whose responsibility was it to have insurance? So is the lack of insurance even something that we would consider in piercing the corporate veil? Because would it even be their responsibility to have it? It's immaterial since that wouldn't be enough.
I mean, we're certainly interested in whether there is a Texas case directly on point that says undercapitalization plus lack of insurance is not sufficient to pierce the corporate veil, and we'll look into that. You cited a case called Ramirez, and I'm sure it's cited in your brief.
Yes, Your Honor, and let me, there's also Shaw v. Maddox, which is 73 Southwest 3rd, 472, and then Durham v. Accardi. This is 587 Southwest 3rd at 186. This states that undercapitalization plus lack of insurance is still legally insufficient to maintain a veil-piercing claim. And in this case, to go back to the statute of limitations issue, we're not arguing a bright line rule in opposition. I think we are on the same page that when statute of limitations expires, a party is entitled to prove that they are entitled to equitable tolling. You don't automatically get it. And Ms. Ledford bears the burden to prove her entitlement, and she has not. She was not diligent. In fact, we have evidence that she began investigating the circumstances of the various parties involved. She sent letters to the Cossey Roping Club. She received an affidavit of no assets and no insurance in April of 2018. She did nothing until December of 2018, where she chose to only sue the Cossey Roping Club. She then did nothing through the next 6 months. June of 2019, limitations expired. July of 2019, she served her first discovery request.
So I understand that. I mean, what I understand the other side to be making, and they can come back to me on rebuttal with this, is that we have the Gentry and the Matthews cases from the Texas Supreme Court with respect to statute of limitations and veil piercing. They're both alter ego cases. The first one was just a straight up, you sued a company and we're gonna allow the suit to go against the alter ego. The second one had to do with, I believe, a case against a company that went to judgment, and then a company was formed to siphon off the assets or something like that. Okay, I get that. The question is, how do they apply in this situation?
Yes, Your Honor, and I see that I'm...
No, that's fine. I'm not even sure that was a question. So, thank you, counsel.
Thank you, Your Honors.
Is it Mr. Ave? You have 8 minutes.
Thank you, Your Honors. May it please the court, my name is Greg Ave. I represent Wesley Settle, one of the 4 directors, along with Ms. Altman's clients, Joe Settle, Katrina Settle, and the sister, Donna Keene. As mentioned, I'm going to try to focus on the factual basis surrounding the undercapitalization issue. So leaving aside whether these claims are time barred, can they get home, i.e. to a fact issue here?
Counsel, do you agree that Ramirez is a good case for the idea that undercapitalization plus lack of liability insurance is sufficient to pierce the court, or is insufficient, sorry, to pierce?
I believe there are probably 4 cases that touch on these issues. Number 1 would be the Wassler case out of the Western District Bankruptcy Court cited in the appellee's brief. Shaw, which is out of the Houston Court of Appeals, again cited in appellee's brief. Then the 2 Dallas Court of Appeals decisions being Ramirez, and I believe Shaw actually is the Dallas Court of Appeals, and Durham, which is a Houston Court of Appeals, all stand for that proposition.
I'm having a really hard time with the Ramirez thing, so I appreciate that you are joining with your co-counsel on Ramirez, but I'm sitting here looking at it, and the court literally says there's evidence in the record that prior to this lawsuit, Cornet I gather the corporation, had assets greater than $250,000, yearly sales grossing more than $1 million, and liability insurance. So it's a case where the corporation had the liability insurance. I don't understand how that can help you in any way.
It is, Your Honor. I believe Ramirez is applicable as to the broader issue with respect to the fact that, to Judge Jolly's question, whether or not capitalization, standing alone, is sufficient to justify piercing the corporate veil under Texas law.
But you understand my question, which is not that, which is we're trying to talk. Let's just assume we all agree.
Yes.
Undercapitalization standing alone, because there's a bunch of cases that say that. Your friend on the other side has said that's not his theory. He's pointing to other things in the record. So now we're talking about undercapitalization plus X. I understood your friend to say X is this idea that just the lack of liability insurance isn't sufficient. So now we're trying to find cases on X. And the first case you've offered me says literally the opposite.
Again, I don't want to represent that Ramirez specifically addresses the issue of whether or not the existence of liability insurance puts the corporate stakeholders, if you will, over the top and not having a sufficient factual basis. I should know the decision better, Your Honor, because actually that was my case. So I think of it as Harari because that was my client. I see the court's point. I believe Wassler is probably a little bit more on point in that respect. But I would also say that I don't believe Castleberry suggests that a lack of insurance is somehow an independent basis that you add to undercapitalization to somehow get. And the last thing I would mention on that point is I believe the focus, both in the district court and in this court, the focus is on we've got evidence of undercapitalization. That's all we need to get home. And that simply, to Judge Jolly's point, is simply not the case. And we think those cases stand for that proposition. In the broader context, if undercapitalization were ever to be allowed by a Texas court as a sole basis to pierce the corporate veil, we submit it would never be applicable to a nonprofit organization. This doesn't have to do with the statutory immunization that exists that was talked about earlier. This has to do with the very purpose of a nonprofit corporation. What is that purpose? According to the summary judgment evidence submitted by Ms. Ledford at page 412 of the appellate record, stated in their certificate of incorporation, or certificate of formation, it was to, quote, provide a local community environment for amateurs and children to participate on a local level to compete in rodeo events, to have a local rodeo night here in our hometown. It is our mission to be a qualified amateur sports organization created to promote community welfare for charity, educational, and recreational purposes, close quote. That's what the stated purpose and intent of this nonprofit corporation was. And to Judge Oldham's suggestion earlier, Kasi is not a town of 500 people. It probably boasts a little over 600 now, according to the new census. Joe Settle testified in his deposition, again, part of the summary judgment evidence submitted by Ms. Ledford, quote, it's a small town community and people just help out where needed, close quote. So let's look at the record here.
Is there any evidence in the record about how much insurance would have cost to address issues such as this?
There is not, Your Honor. Again, that question was not
It just occurs to me, if it costs, a policy that would cover such insurance,
that is
quite
correct.
expensive, and also makes it quite akin to undercapitalization.
Right, and I believe that.
Well, I mean, if they said, why didn't you have liability insurance? Well, we couldn't afford it. I mean, is that evidence of fraud that you can't? There has to be some fraudulent intent, some malevolent, at least a touch of malevolency in it. It seems to me to constitute fraud.
Absolutely, Your Honor. And to your point, again, Mr. Suttle testified in his deposition that he believed that the rodeo producer had insurance and provided insurance for the event. That was his testimony. That was his belief. And I agree. This goes to the discussion about Ramirez and your question just now, Judge Jolly, that
I mean, had any injury ever, is this the only injury that has ever occurred?
I believe that is 100% correct, Your Honor. It never has
How long has this rodeo existed?
decades upon decades, Your Honor.
Beg pardon?
Decades upon decades.
This is the
Over 20 years, I believe, closer to into perhaps the 80s.
It would be difficult to say that it was irresponsible not to have liability insurance. I mean, you could,
Absolutely.
no accident has ever occurred.
And to your point, Your Honor, I believe liability insurance is simply another asset that a corporation has. It is not some special wand. And if the legislature wanted to compel a nonprofit to have insurance, it certainly is entitled to do so, but it certainly did not in this case.
And I think that's a fair point. The thing I'm so flummoxed by is that if the court says to you, do you have a case where the undercapitalization plus the lack of insurance is insufficient, and you offer 4 cases, the thing I'm getting flummoxed by, it's one thing these are all reasonable arguments, but the cases you've given us, one is a Western District of Texas bankruptcy case. It's obviously not a state case at all. Shaw doesn't involve liability insurance at all. It's an oral contract for a life insurance policy. So, and we've already been through Ramirez. So, I mean, I think it's fair to say, no, we don't have a case. What I'm struggling with is, yes, we have these cases. They all say the opposite of what we need to prevail.
Yes, sir. May I respond?
Please, I'm sorry.
I agree with the court that the authorities we cite focus on this inability of undercapitalization to be sufficient in and of itself. And to my estimation, the reason that is responsive to your question, while factually not directly on point, we readily acknowledge that, is that the insurance is nothing more than capitalization, as I don't believe Judge Jolly said, but as his statement intimates, is the idea of what is an insurance policy? It is nothing more than an asset, period, end of statement, to protect you from certain liabilities. Not all liabilities, but some liabilities. Would it apply to this one? We don't know. All we know is that they didn't have it, and they thought the producer of the rodeo would have it. Thank you.
Counsel. Did you have any other questions? Thank you. Mr. Talbert, you have 5 minutes for rebuttal.
Thank you, and may it please the court. Time permitting, I'm going to run through 4 points on rebuttal: equitable tolling, undercapitalization, what the record actually shows, and then this nonprofit issue. We heard from opposing counsel these efforts to get away from Gentry and Matthews. I think we heard at one point, well, it predated Castleberry. Piercing the veils existed since 1901 in Texas. There's no predating it. And here's what those cases say. Gentry says suing the entity, quote, stopped the running in favor of the other one. Matthews says, quote, was told as to the other entity. That's the direct language from these cases. You have 2 cases on point saying it stops, it tolls the running, and it's a mechanical.
Is it a bright line rule or not?
I apologize. I should have called it a mechanical rule. It's not a bright line rule.
Bright line rule. It doesn't matter that they say that. What matters is whether we can intelligibly apply the facts in this case to those cases which are different. So I take your point that there's still good law.
Certainly, Your Honor. Let's touch on number 2, this undercapitalization notion. And, there's kind of been the battle of kind of authority that gets around the issue but doesn't actually get to the issue. I hear that. What we're putting forward to the court are a slew of cases that note that undercapitalization is good. Supreme Court of Texas, Castleberry. Supreme Court of Texas, Lucas. Wilson v. Davis, undercapitalization was a factor. The S-Line v. B2B, Northern District case. And the last one I'd note was a Daglish case. And here's what the
fair to say that undercapitalization can be a factor in determining whether to pierce the veil in a tort case?
I would go further than call it just a factor, because remember what Castleberry tells us? It says that it can be an independent vein. Mind you, it said we have 6 veins, and then it drops undercapitalization and says, and maybe there's a 7th one in a footnote, but I would submit that based on Castleberry, it can stand alone. And so here, construing Castleberry is what that Daglish case says. Quote, generally inadequate capitalization as part of a fraudulent scheme will support piercing the veil. And so I think that goes hand in hand with Castleberry, that if you've got constructive fraud, the injurious to the public, the tendency to...
Where is the constructive fraud here?
Sure. And so the definition of constructive fraud was a tendency to deceive, to violate confidence.
Where is that? Where's the evidence of that? They've had no accident in the decades that they've been running the incident. I mean, they have no money. They give what little money they have to the charity. So where is the evidence of fraud?
And that's a great segue to 3, and I want to answer that. What does the record show, and is there enough to raise a fact question out of constructive fraud? Here's what the evidence shows. We heard, well, he just never foresaw this. That's not true. On 535 of the record, it says, is this a dangerous event? Yes. Was it foreseeable someone could get injured? Yes. Would it have been responsible to have gotten insurance? Yes, yes, yes. But you swept the funds and were never in a position to compensate someone who was foreseeably injured at your event. That's exactly what happened. And so, on the definition of constructive fraud, injurious to public interest, remember, they have shifted the risk to the innocent members of the public. They said, come to our dangerous event. We formed a corporation. If you get hurt, too bad, so sad. Is there at least a fact issue on that point? Absolutely there isn't.
I'm pretty sure they didn't advertise a rodeo that way.
Well, no, they didn't say come to our danger. That would be a terrible marketing scheme, even to 600 people in Kasi, certainly. No, I agree with that. What I think is important here also, we're talking about a factual dispute. They're arguing the benefit of factual inferences. What this man maybe intended or did, that is a question for a jury. And so the fourth element I'll note is this notion that...
See what the question for the jury is.
I know I've said this, and...
you haven't told me, or at least I haven't heard it.
The question would be, is the use of the corporate form, does it result in injustice?
That's a legal question.
Under the pattern jury charge 108.4b, that's...
If you have any evidence, any disputed evidence...
I think the disputed evidence would be whether or not this did result in some form of constructive fraud that was injurious to the public interest. That resulted
in disputed fact. Okay.
Well, and I guess I would just lean on, again, Castleberry saying, and except in exceptional circumstances, this is a fact question for a jury. And the nonprofit status doesn't alter that. The statute doesn't alter that. And so I'll wrap up here. With all that said, I'd request the court to reverse the trial court's order granting summary judgment.
Thank you, counsel, for a vigorously presented argument on both sides. That concludes our oral arguments for today, so we will stand in recess until tomorrow morning.